afternoon. The Committee on Licenses and Inspection will now come to order. Having established a quorum, to my right, Councilman Domb, to my left, Councilman Bill Greenlee, and to his left, Councilwoman Blondell Reynolds Brown, who's been appointed to this committee for the purposes of this hearing, and Councilman Heenan has also joined us. For the purposes of information, I want to make sure that folks know that there is a L&I hearing on Monday at 1 o'clock for bills number 180992, 180953, 180107, 180700, 171112, 180745, 180746, and 181008. Today's hearing is on two bills, Bill number 180939 and Bill 180940. Will the clerk read the title of both bills?
Bill number 180939, an ordinance amending Chapter 3900 of the Philadelphia Code entitled Property Licenses and Owner Accountability to modify application notice requirements and penalties for noncompliance, all under certain terms and conditions. Bill number 180940, an ordinance amending Chapter 192600 of the Philadelphia Code entitled Business Income Receipts Taxes to modify application requirements for commercial activity licenses, all under certain terms and conditions.
Thank you. The chair will recognize the sponsor of this bill for opening remarks, Councilwoman Blondell Reynolds Brown.
Thank you very much, Madam Chair. Before I get started, I do want to say a huge thank you to the chair of this committee, Councilwoman Maria Quiñones-Sánchez, and her staff for squeezing this committee hearing in before the holiday. And I want to thank all of those who are able to join us in this License and Inspection Committee to hear on bills number 180939 and 180940, both introduced by my office on October the 25th, 2018. These two bills, if passed, would increase the transparency and accountability of LLCs, both residential and commercial. The purpose of these bills is to increase the transparency and accountability of LLCs. A little background on the introduction of these two bills is necessary. In crafting this legislation, ultimately aimed at ensuring that no child is lead poisoned by paint in the city of Philadelphia, my staff and I, for the past 18 months, have met with advocates, landlords, leadership of HAPCO, parents of lead-poisoned children, nurses, lawyers, doctors, and multiple agencies. Over the course of the last year and a half, my staff and I have met with HAPCO 3 times, as well as a separate meeting with the Pennsylvania Apartment Association. We have held multiple meetings, each with the Department of Health, the Department of License and Inspection, and the Law Department. And we have met several times with advocacy groups, including the leadership and team at PCCY, Community Legal Services, and TURN. So we have cast the umbrella wide and listened to all voices on this matter. One of the concerns raised in these conversations was the fact that many LLCs were nearly impossible to contact about issues regarding lead paint, as well as other causes for concern that are raised by both tenants and city agencies. We have also learned that these LLCs were also impossible to contact regarding standard communications needed for doing business, either by tenants or by city agencies. My staff and I were asked time and time again, where is the accountability for these many faceless property owners? Why is there limited or no transparency? How can the city allow unlicensed landlords and business owners hide behind paperwork and ineffective business addresses? My staff and I were also told about tenants filing complaints against their landlords only to receive the communications in their own mailboxes. My staff and I listened to tearful parents and family members who would share with us the untenable conditions of their apartments with nowhere to turn. My staff and I heard from city employees about the maze of false information they have to work around to serve Philadelphia's citizens. Fact, in the city of Philadelphia, LLCs are sometimes used to shield property owners from personal liability while obscuring their identities. The result of these hidden identities oftentimes with unlicensed landlords, means that many tenants and some of our most vulnerable citizens struggle to hold landlords accountable. The result of these hidden identities means that the city cannot adequately address or fix blight. The result of these hidden identities is that we as leaders are unable to answer basic questions oftentimes about our own housing market because we can't collect the necessary information to document what the status of our housing market is. These two bills not only allow the city to identify individuals who hold financial interests in each registered LLC, but they also require that they list a managing agent that is able to not only be contacted by tenants, but also to receive legal and government notifications. The goal is not to publicly disclose home addresses or break any business owner's confidentiality. Repeat, the goal of this legislation is not to publicly disclose the home addresses or break any business owner's confidentiality. The goal is transparency so that we can get to those bad actors, typically unlicensed landlords, most often who have lead in their apartment properties. We fully expect city agencies to issue policies that protect all privacy rights granted by this law. We know that LLCs serve as a legitimate business purpose by the majority. However, as long as children are being poisoned in the city of Philadelphia, we have to look for other small incremental steps to get to the root of the problem. We're not there yet. We're not there yet without transparency and accountability on the people behind those LLCs. We leave our citizens and our taxpayers uninformed, vulnerable, and in far too many cases, victims of predatory business practices. We have circulated amendments to both bills in response to concerns raised by both the administration and the landlord community. We heard you, and we've acted on those concerns. The effective date for these bills is now January 1, 2020. I repeat, the effective date for these bills is now January 1, 2020, to allow full integration of these expectations in the new Eclipse computer system. And we want to thank the administration for the ask, and we've responded to the ask so that those departments can do what they need to do for us to allow the delayed implementation of these bills. In response to landlord concerns, we have clarified that equity interests need only provide a mailing address and not their home address. We don't want your home address. In response to landlord concerns, we have clarified that equity interests need only provide a mailing address and not their home address. Thank you to all of those stakeholders who participated in the numerous, long, it's okay, myriad discussions that we've had for the past 18 months, focused on how we get closer and close another loophole in addressing lead, as well as fostering better relations between landlord and tenants. Thank you, Madam Chair.
Thank you. For the purpose of the record, the chair recognizes that Al Tallenberger is also here at the meeting. So we will start, did you want to do both bills at the same time?
Yes.
Okay. So I'm going to invite the administration, represented by Rebecca Swanson, to come in and testify for both bills. Then following that, we will have a panel of George Gould, Colleen McCauley, Carla Krull, and George Donnelly. For the purposes of the record, written testimony has been provided by the Pennsylvania Apartment Association, the Greater Philadelphia Association of Realtors, and HAPCO. You may proceed. Welcome back.
Thank you. I have separate testimony on both bills. Do you want me to just read them both back to back?
Please.
Okay. Good afternoon, Chairwoman Quiñones-Sánchez and members of the Committee on Licenses and Inspections. My name is Rebecca Swanson. I'm the Director of Planning for the Department of Licenses and Inspections. I'm here to provide testimony on Bill Number 180939 as amended, which amends the requirements for rental license applications set forth in Chapter 3900 of the Philadelphia Code. Any property owner who rents out all or part of their property is required to obtain a rental license from L&I. This license must be renewed annually at a cost of $55 per unit. This bill would change the rental license application to require corporations to disclose the identities of principals or individuals with equity interest in the corporation, both at the time of application and any time ownership changes. The department supports this effort and is prepared to undertake its implementation in the future. Practically speaking, this will not affect the rental license issuance process, but in requiring corporations to be more transparent as to their ownership structure on their applications, the city will now have additional tools to contact licensees if there are code violations at their properties. This will make the enforcement process instituted by L&I and the law department more effective and efficient. The bill also requires that property managers, which are required for landlords who live outside of Philadelphia, accept all communications directed to the property owner. Finally, the bill increases the penalty for licensed applicants who provide false or misleading information about their ownership of the corporation. L&I has requested an amendment changing the effective date of the requirement to July 1st, 2020, in order to give the department sufficient time to revise the rental license application to reflect the new requirement and to properly notify licensees. Thank you for the opportunity to provide the department's testimony. And now I'll skip over to Bill number 180940 as amended, which amends the requirements for commercial activity license applications as set forth in Chapter 19, 2600 of the Philadelphia Code. The commercial activity license, or CAL, is essentially the way a business registers itself with the city for tax purposes. The license is free and does not expire and can be applied for and issued to individuals or corporations. This bill would change the CAL application to require corporations to disclose the identities of principals or individuals with equity interest in the corporation, both at the time of application and at any time that ownership changes. The department supports this effort and is prepared to undertake its implementation in the future. Practically speaking, this will not affect the CAL issuance process, but in requiring corporations to be more transparent as to their ownership structure, the city will have additional tools to contact licensees if they commit code violations. Again, this will make the enforcement process instituted by L&I and the law department more effective and efficient. L&I has requested an amendment changing the effective date of the requirement to July 1st, 2020, in order to give the department sufficient time to revise a CAL application to reflect the new requirement. Thank you for the opportunity to provide the department's testimony on these bills. I'm happy to answer any questions at this time.
Thank you. Real quickly, before I recognize my colleagues, why must the city track equity interest owners?
Well, we're not really, the equity interest thing aside, having an individual as opposed to a corporation is important for a number of reasons, as far as the city contacting the owner. If it's just a business on there, if we need to get to a person, such as if there's an emergency at the building, at fire in the middle of the night, and we need to call somebody, if we need to do a cease operations, if we're trying to get service on a person to bring a case for code violations, it makes it much easier, more efficient if there's an actual person that we can call and contact, both for the benefit of anyone who lives there, both for the benefit of the city, and then in some cases to the benefit of the property owner. If the city needs to do something at your property on an emergency basis, wouldn't you like to know? And if we have your name and your phone number, we can tell you, rather than us taking a unilateral action and telling you after the fact. It's better communication, more transparency for everyone.
So over the last few years, you've spent quite a bit of time, almost your personal journey, around some of this property maintenance issues that we've been dealing with. Can you, for the purposes of the record, I mean, how much energy have we invested in research? There have been bills around property maintenance code, Councilman Heenan, Councilwoman Parker, Councilwoman Tasco, around requiring a locally based real estate agent. Yep. Can you speak to how much time we've spent on that and how effective or ineffective that's been, which leads us here today?
The property maintenance code is my life. I don't know what that says about my life, not that interesting. No, we have spent, my whole life is the property maintenance code. Very boring life. We have spent a lot of time trying to identify this problem of delinquent property owners, people who are just abdicating their basic responsibility as a property owner to keep it to the bare minimums required in the property maintenance code and the fire code, particularly around landlords. Owner-occupied properties, the owner has a vested interest, they're there. But rental properties, in some cases, in the vast majority of cases, landlords are fantastic, whether it's somebody who owns one or owns 1,000. They are responsive, they get a rental license. We believe that 80% of our rental units are licensed. You can't get a rental license if you have code violations at your property. So we know that the majority of our rental properties are fine, but there is that percentage which have violations and are blight on neighborhoods and are problematic both for their occupants and for neighbors and for the city, because we spend an inordinate amount of resources trying to track these people down, doing inspections, filing code violation cases in both municipal court and in equity court. It's resource drain on L&I. A lot of our inspections, a lot of our complaints are from tenants about rental properties. The law department spends an inordinate amount of time, and there's a lot of times we have problems with service, so with actually getting a person. So we've been chipping away, and we're trying to drill this down to the point where the people we go after are actual bad actors, really focusing our resources on these landlords who don't get any rental licenses, maintain their properties not at all, and really have serious substandard conditions. And being able to focus our resources on that while chipping away and getting everyone else to kind of take responsibility. Just be transparent, be accountable, just increasing the penalty for being dishonest. There's always going to be bad actors, just a fact of life, but we're trying to concentrate our resources on going after the real bad actors.
So, we've seen a move. By any chance, do you have any numbers around property, the increase of property ownership by LLCs, right? And why do people move to LLCs versus disclosing who the owners are?
It's all lawyers' fault. It's all the lawyers. They are advising their clients to set up an LLC to avoid personal liability if there's an issue at the property. I don't have numbers as to how that has shifted. We do know that about 40% of our landlords are small landlords who just own between 1 and 4 units. Obviously, and with the LLCs, one of the main problems is an individual may set up 20, 30, 40 LLCs, one separate LLC for each of the properties they own. There's 1, 2, 3, 4 Market LLC, 1, 2, 3, 5 Market LLC, all owned by the same person. L&I has developed kind of an algorithm that our data people use to try to connect all those LLCs back to a person. We call it our alias list, but it's manual. It's a lot of work, but we've identified kind of these large-scale owners who own 300 properties in 40 different corporations. But it's a lot of work, and we know we're not getting everyone. So the more transparency and the more information we can get from property owners, the better at going after these larger LLCs who, if you own 300 properties and 50 company names, you're probably up to no good. Not to cast a broad net, but it's those people that we're worried about.
Yeah, so over the summer, we did a mailing to promote our TAP program. And then we went door knocking. And we found that the list of the water department was like 95% bad. That when we knocked on the door, most of the time there was an LLC or a tenant in the property versus what our records showed that it was owner occupied, right? Eligible for homestead, eligible for the other information. We've seen a growing trend of these LLCs at the sheriff's office, speculating. Yep. And I know we're working with PGW, Water, and PICO around sharing data, because now L&I, it is a bill that we've pursued, as Councilman Domb knows, as a way of, again, adding to the data sets that we have. Exactly. and aligning the data sets for the city so that we can get a better handle on this, right? We've had an enormous debate around affordable housing and access to quality housing here. And, we don't legislate for the perfect, but all of these pieces are, as you say, chipping away at removing blight and the bad actors. How does the department respond to the concern about disclosure around equity owners? People feeling like we're going to put their business out there. How do we respond to that? And how's the data going to be used, and where is it going to be available?
So rental licenses are public documents. The information on a rental license is public. The vast majority of our data is public. It's basic transparency. And I haven't taken, it was 12 years ago that I took corporations in law school, so I can't speak specifically to equity ownership and what that would look like and what has to be disclosed. But for L&I purposes, we're not analyzing corporate documents. We're not saying, oh, you actually have 26% interest, you have 17. We're just having that name so we have someone to contact and someone for the law department to attempt service on. It's really property ownership. You have a responsibility to be transparent, to be honest, and it's really increasing the penalty if you're being dishonest. But I can't really speak to the whole privacy, what you're required to disclose and what is supposed to be private.
Okay, I'll allow my council colleagues to ask some questions. Councilman Bill Greenlee?
Thank you, Madam Chair. Just very quickly, just for the record, the sponsor in her opening remarks talked particularly about the lead issue, and I know some of the people who are going to be testifying are focusing on that. But just for the record, this goes well beyond just one issue, right? For the city, as you say, there could be myriad reasons why you need this information, and many code violations that you need to follow up on. So this is a overall issue, right? Not just based on one particular problem, even though that might have generated some of the discussion. Am I right?
Exactly. Yes, this is for any code. It would give us contact information for if any code violation is discovered at the property.
Right, okay, all right. Thank you, Madam Chair.
Thank you. The chair recognizes Al Tollenberger.
Madam Chair, thank you very much. When it comes to lead, how many lead violations are given out by L&I, approximately? I mean,
Lead violations are written by the health department.
well, do you have a sense of how many there are?
I do not.
Okay. They're written by the health department.
Mm-hmm.
Right now, how many LLCs have no human contact, in the sense there's no person saying, I'm the manager, I am the person in charge, I am maybe the owner? How many do that now?
I don't know. We don't keep data in that way. We do require on the rental license application to disclose the owner or operator of the property.
Well, let's say it's, for the sake of argument, it's an LLC that has 100 owners. I mean, it's possible.
Mhm.
What do they put down? Just the LLC and?
On the current rental license application, it has the name of the owner or the operator and their address, their tax ID number, all of that information.
And that's of the LLC?
Of the owner or operator. It doesn't have to be the property owner that applies for the rental license. The rental license can be applied for by your property manager.
Right.
And that is also if you have an
Is that required to have a license? I mean, when is a property manager required or not required?
If the owner is, their business address is outside of the city of Philadelphia. Or you could be within the city of Philadelphia and just have someone that manages you have a bunch of properties, you don't want to manage them yourself, you have a property manager, and it says name of agent. That would be your property manager. That's also to be filled out on the form if that's applicable.
Is that data available in some form? Like let's say it's A.W. Taubenberger LLC, but Taubenberger represents 100 people. Let's say, for the sake of argument, it's 100 people in this LLC. What else are they then required to give? I can give a P.O. box, I can give no phone, do I have to give a phone number?
Are you talking about on the current or what the?
Current.
Yes,
Current.
you can't give it, it's the name of the owner or the operator.
Which is, let's say, ABC LLC.
Yes.
I'm not using my own name.
Your
otherwise.
address, but it cannot be a P.O. box.
Oh, your address, okay.
Your tax ID, your commercial activity license, and then so if you have a property manager, and then contact information, who is the person that's receiving the communications, daytime phone number, evening phone number, a fax number, which
For
anyone
that,
uses, and an email address.
for that person who is designated as the
Yes.
manager.
Yes.
So that LLC, the ABC company, has to provide a real name.
It does, on the current application, it does not need to provide a person's name. It has to provide contact information, but does not need to put, it is owned by Mr. Al Taubenberger. It is, the LLC. And that's what this bill would do, is
Okay.
require that additional name so that there is an additional person to effect service on. You can't serve It's easier to serve a person than a corporation.
Do you have a copy of one of those applications?
I have a copy of the current rental license
Yeah,
application.
that's what I
if you
would
want
like,
me to
yes.
pass it up.
Yeah, I'll come get it. I mean, it
Yeah,
can't be that formal here.
It looks different online. We actually
Well,
are pushing
how different does it
everyone-
look online? It's really the same
It's
information?
the same information, it's
Got
just, we don't
Okay.
want anyone to use that anymore. We want them all to do it on Eclipse.
You can, yeah.
We
Yeah.
don't want you mailing that in, but I just printed out a copy of.
Well, I'd like to take a look at it, and Madam Chair, I'm finished with my questions at this moment.
Okay, thank you, Councilman. Chair recognizes Councilman Heenan.
Thank you, Madam Chair. And for the record, I want to thank the chair and the sponsor for, talking about these issues, because they are the issues that really reflect the care and attention that we give to our communities when it comes to the bad actors, as Deputy Commissioner was talking about, because there are some bad actors, and the struggle that we have in this body is determining who's a bad actor and who's a good actor, right? And I think that's the balance that this body brings, and I do also remember the bane of your existence, Rebecca, and a lot of the chair here is rewriting the property maintenance code, which took a couple of years to do. But it was, I'll tell you what, you really get to learn about how the code affects the quality of life of every neighbor in the city of Philadelphia. Couple questions when it comes to this legislation. So just some question. What does in the current format of somebody who applies for an HIL license, you have to fill out this application. Some fields are required, some are not, when it comes to having a managing agent or property manager, only if you it's required if you live outside the city and have properties in the city. And I know that has been a big issue. So what is the department, all right, so how many applications and HIL licenses do we have in Illinois currently as we speak?
There's about 80,000 active rental licenses covering about 200,000 units, but if you have multiple units, they're all on one license. Every year, we get about 10,000 brand-new applications and about 70 renewals of an existing
Okay, so
license.
there's a drop-off of 10,000 every year.
Yeah, and that
with
holds
the
about steady
replacement. So
over time.
for one reason or another.
Yeah.
So there's 270,000 investment properties, 70,000 consistent would be your baseline, and 20,000, fluctuation with new and people dropping off. That leaves a lot of room for L&I and the utilities. I know that this council and Councilwoman Sanchez in my office and others have been working towards for years and years and years to go after those who have habitually, all right, and willfully, all right, do not apply for a renter's license. And they're the ones who are the most egregious to our communities when it comes to responsibility to their neighbors and their block, and responsibilities to the tenant, all right, that they put into our communities, all right, because they take advantage of them. They're predatory by nature, and they're destroying the quality of life of our nature, and it's wrong. It's just flat out wrong. So how do we get to those bad actors? The Councilwoman and others, we've been trying to work with the utilities to, with the water department. Most utility water department landlord pays, the investment owner pays for the water. All right, I believe in most cases where somebody has multiple addresses but one account, that can easily be cross-checked. So it gets complicated with the water, gas, and some other utilities like PECO without having breached any kind of disclosure, right? Confidential information, which I don't think we are asking for. We just want an address right, to cross-reference to see, it's that simple, all right?
Yes.
An address to see who is renting and who is not, and who doesn't have a renter's license, all right, because they're the bad actors, all right, that continues the broken glass theory. With that being said, what is L&I's verification process to validate, all right, and to ensure that the information currently is correct and, in fact, true as a statement of fact?
So when a license is applied for, and this is any license, we issue about 120,000 total licenses a year. Obviously, rental license is a huge bulk of that, but every other business license, every other trade license, there is a signature line where the applicant is certifying that all of the information is true under penalty of law. And that is the verification system. L&I does not verify information that is on the rental license application.
So we're not verifying the 80 to 120,000, applicants that have, or applications that have been coming through our system now?
There is a tax compliance check for all licenses. In order to get a license, you'll get a tax compliance check that happens
So the
automatically.
property maintenance and NOVs and any kind of L&I violations are current. So the house is current on its CVNs and NOVs.
Correct. So to get a rental license, you get a tax compliance check with the Revenue Department. That's for every license. And you also cannot renew your rental license, receive or renew a rental license if you have open property maintenance violations. CVNs, if there's open CVNs for trash and things like that, those you can still renew your license. But if there's an actual NOV open case that's been unresolved and that hasn't been appealed, you can't get your license. So the people who do apply for a license theoretically do not have reported or known property maintenance violations
Right.
at their
So
property.
the ones that we have on the books now and that we're aware of, I'm not saying everybody's a good actor, right? Because there are a lot of bad actors out there. But for the most part, they know that they need to get a renter's license.
Yes.
Okay.
We believe there's about 260,000 rental units in the city that require a rental license, and about 220,000 of those are licensed. So we believe there's about 40,000 unlicensed units. That doesn't mean buildings, it means units.
Right.
And those are the number that we need to focus on, because I think in there is the properties that have the most serious violations.
So we're relying as it is. I don't mean to cut you off. I'm going to try to get my questions in before I have to exit, unfortunately. But and I will put this in writing to you, to the chair of the committee, and to the sponsor of the bill, some of my questions and concerns. I'm trying to state the fact that we have a capacity issue with the city's Department of verifying, because we're relying on the bad actor, if they're bad actors, all right, for those who are applying for a rental license. We're relying on that information to be true in fact, all right, and we're not fact checking it.
And at some point we have to. I mean, it would be a waste of resources to sit and verify every cell phone number. It's not physically possible.
So as we move forward, right, with, I'm going to say this legislation here, we're going to be adding on more work and the ability for a little more complex, ownership verification when we're not even verifying what we have. I think there's a way to get there. I just want to know, I just want to try to, come from a good starting point on what we're doing now and what we can do better. The other thing is, what is the law department going to do? So you have somebody that's in violation currently and/or in the future with future legislation. Is the law department going to have to, who's already underserved? One, I know the law department has an issue with service notices, so that's one. And two, are they going to have to take every individual property to court themselves on an individual case in order to be in compliance?
I don't want to speak for the law department, but what this does is, like I said, it's chipping away. and it's requiring more transparency and openness from the applicants. They get a rental license, and they tell us who they are. So that way, the law department, when they go to try to effect service if there is a violation, or they need to contact someone because we need to do a cease operations and these people need to be relocated and we cannot get somebody on the phone. That's what this piece will do. It'll get that contact information there. So the idea is not to then do research to make sure that everyone put down the exact correct equity owners in the property and then prosecute them just for failure to do that. It gives us contact information, but then also if one of these people is already, we're bringing them to court, we can't get them because they did not give us the person's name.
My point is,
we have that additional penalty.
But we don't have we don't have valid contact information for the people who have applied, let alone new applicants. I'm just pointing that out.
Point of information, please, clarity. The purpose of the bill
recognize Councilwoman
is for
Blondell
transparency and accuracy of records. What I heard you say in the beginning of your testimony was, if you had more accurate information on these documents when they're filed, the department would actually spend less time trying to hunt down landlords when they're in violation. So to the degree that we can minimize, decrease, ultimately eliminate, and that will never happen where we have zero sum of everybody doing the right thing,
Oops.
to the extent that we can move that number from whatever the percentage is now, which I believe you said it was 80% of those who are providing the accurate information, if we could increase that to 90% by asking for more complete information, then we move ultimately towards a circumstance where we're closing the gap of those landlords who are not being transparent.
Yes.
So for me, it's immaterial that we don't have enough expertise, human resources in the departments now. We're simply asking for more information given the resources that we have.
Yes, it's putting the onus on the property owner to tell us, to give us more information, and like you said, it allows us to, the resources that we're currently spending trying to track somebody down who didn't give us a name, we just have the LLC, those resources can now be redirected into chipping away at the unlicensed landlords, the actual bad actors. It allows us to redirect resources by putting some additional requirements on the property owner, like you said.
Thank you for the clarity.
Thank you. Councilman Heaton?
Thank you, Councilman. And I totally agree with the Councilwoman. We want to move the needle. We should be striving for, instead of 10,000 new HIL licenses every year, we should be striving for 30,000 because of the drop-off. But the fact of the matter is, all right, is yes, we want to get better contact information that's factual and true and correct, but we don't have it now. All right, we don't have it now. So I'm just, and that's a fact. And last, this is one of the recommendations from the eviction task force. Is that correct?
I don't know if it made it into the final report, but it was, I was on the task force, and this was something that was discussed in the context of many other
All right,
recommendations,
and
yes.
the eviction task force, not that this has anything to do with evictions, had met for how long? About a year?
About 10 months, a year.
About a year. I would like to see, is there best practices anywhere? Have we even looked into best practices on this issue elsewhere, or spent any time on this issue elsewhere with other best practices in municipalities in major urban cities in the country?
I'm not aware of best practices around rental license applications or information that's gathered in other cities. I don't believe that we undertook that study, but L&I did not. I can say that L&I did not do that type of research.
Okay.
I can answer that question. We spoke at length with Rochester, your peers in Rochester, New York, and also in Maryland. And the idea was, I can't say it was strictly accredited to those conference calls that we had, But what became clear in talking with your peers in Rochester and in Maryland was that that our city can do better, and one way to do better is to get more information on the document. So I don't know about best practices either, but I do know in talking with your peers in those other cities that this is something we could do or should do.
Thank you. Councilman Eden?
No further questions.
Okay. Councilman Tollenberger?
Thank you, Mr. Chairman. If I'm a bad actor and I have my ABC company and I give you false information purposely so you can't track me down, you said this was under penalty of law. What kind of law and what are the penalties for that?
It is currently in Title IX. Hold on, let me find it. That
I know.
this bill adds,
Could you repeat that title?
I'm sorry, in Title IX, in this bill, in
Oh,
93900, in Bill 180939, that would say, it adds a penalty that knowingly providing false or misleading information on this issue, on the application, becomes a Class 2 offense. So that, which is,
What does that mean?
means that the city can write you a violation for a violation of this section that carries a fine with it. So the
Okay, but what does that, I mean, my point to you is, the point I want to make is, what is the actual penalty? I mean, is it a small amount? Is it a big amount? What do they have to pay? Imminent execution focuses the mind.
300? The law department tells me that a Class 2 violation is $300 per occurrence.
We are entitled in this body, I believe, to raise that amount, are we not?
I believe so.
See, that's right, I think. And how much can we go? I mean, we are limited by state, but at some point, we can raise that above $300. Because $300 to some LLCs, in fact, probably to most companies, is not a whole lot. But if you're dependent on this information, and the public is dependent on the information, and you either purposely lie, which people do, but also, let's say the information's out of date. I think as the owner, you have a responsibility to update this. Do you not?
Yes, and that is in the bill, that you would be required to update the information, which we know in the past was difficult, because you would have to fax it to the department, and you didn't get, but now that, what we're doing is everyone do it online, do it through Eclipse, and you have an account, and you
Okay.
can, in 2 seconds, go into your account and update your information. And I know coming out of the eviction task force, like the councilwoman said, there's been discussions, and there have been discussions about fine amounts across the board for all property maintenance code and Title IX violations. And if our fine amounts are at the right amount, are they too high, are they too low? What do other cities do? And I think there is a movement to look at best practices and what other cities do and where those fine amounts
If
should
you
be.
really want accurate information, I would urge my colleagues and others in the department to raise it to what we're allowed to raise it as a city. I mean, I don't know why, if it's too low, too high. If people are in violation of this, and it's the importance that it is, it really should be raised to the highest amount that this city is allowed to fine people.
Which I believe is 2,000, but I could be.
Wow, that gets people's
Could be
attention
wrong.
more than 300.
It's true. That is very true.
I mean, really, if you're out to dinner with friends and all of a sudden the bill's $2,000 and you expected 300, somebody's going to start looking at one another and say, how did we get to this? Who ordered all this food? So my point is, the higher the amount, the sharper the pencil, and the people will remember to do this correctly, and also to advertise that.
Yes, no, agreed.
Thank you, Mr. Chairman.
Chair recognizes Councilwoman Blondell Reynolds Brown.
I thought Domb was,
Oh, I'm sorry, Councilman
That's
Domb.
okay. It's all right.
Go ahead.
Okay. I just want to make sure I understand. Thank you, Madam Chairwoman, and good afternoon. I think what you're saying is there's 80,000 licenses. Is that licensing 220,000 investment properties?
No, this is rental units across, all rental units.
Okay,
So it doesn't,
So let me give the sphere that I know. We have like 576,000 tax bills. Of that amount, how many are rental properties?
there are about 80,000 parcels that are used that have a rental license on them, representing 220,000 units. The vast majority of our rental properties are 1 or 2 family row homes, typical home. Then there's about 5% that are 5 or more units, the larger
I see.
apartment buildings.
And so how many, and you think there's another 40,000 that aren't registered?
We think there's about 40,000 unlicensed rentals. Some of those might just be a guy who doesn't know he needs to have one. Some of them are bad actors. And we've been working with your office and Councilman Heenan and Councilwoman Sanchez's office to try to find out who those 40,000 people are, particularly using the utility data. That's where, and we thank all of your offices for really helping us move that needle, because I couldn't do it by myself. Nobody was listening to me.
But the 40,000, is that are those mostly the bad actors, the ones who haven't registered?
We can't paint it with a broad brush and say all 40,000 of them are a bad actor, but I will say, to get a rental license, you can't have open code violations at your property. So the people who have a rental license, by and large, are keeping they may have violations all over the place, we just don't know about it. But the other 40,000, the conventional wisdom would go that some of those do not have a rental license because they can't get one, because they have open violations. Or they are just running it they're never going to get a rental license whether they had violations or not.
So the 40,000 that don't have a rental license don't have a rental suitability license either.
They have nothing.
So theoretically,
We don't know
those
where they are.
40,000 properties who have tenants don't have to pay rent.
Correct? They would not, you
Wouldn't
do
that
not
be
have to pay rent if there is no rental license.
Right, if
You have to
I-
escrow it.
Right. If I wanted to make sure the 40,000 people got their rental license, would I not, well, they don't have a rental license, and do they have a business privilege license? I don't know, but I would suspend all their licenses and notify their tenants, there's no licenses here, you don't have to pay rent.
We
And
don't
bring them
know-
into the city to get a license.
We don't know who they are. That's the
You know,
problem.
you have the property addresses. And I will say this, every tenant who's writing a check to a landlord knows where the landlord is, or knows where to send the check to it, I should say.
And what we hear from people is that a lot of times it's cash. A lot of time they just they're told to just drop off a check or a money order or something like that to people. But you're right, I think there is a lot more that we can do using data to try to narrow down that 40,000 to say, we know this is being used as a rental property. I think in
Utility
conjunction
stuff
with
is
your
correct.
offices, we're going to make some headway there using utility data. Like I've been saying, we're just trying to chip away as much as we can to get that 40,000 number down significantly.
So in the 40,000, would it be, I think we're all in favor of the goal. The question is, how do we get to the goal? On the 40,000, would it be a potential goal to notify those landlords, if we could, that without a rental license, your tenants do not have to pay rent, and if you don't come in within X amount of days, 30, 60 days, we will notify your tenants that there's no suitability license here, and under that law, rent is not required.
We have had those discussions, and I think the goal would be if we come up with a list based on this review of the utility data of all of these properties that we believe are being used as rentals, we would send a letter to those property owners. We would identify an offsite address, send them a letter to say, we believe your property is being used as a rental license. You don't live here, so you either need a rental license or a vacant license, and you have 30 days to do so. And we have had discussions about, like you just said, sending it to the tenant as well, calling their attention to the section of the code that states that rent can be escrowed if there is no rental license.
Right, and so that there's two issues, I think. One issue is for the people that haven't come in and gotten a license at all. We don't even know who they are, and you can't contact them, as you're saying, in emergencies, which is a problem.
We don't even know where.
That's a major
Yeah.
problem. They're really the bad actors, by the way. They're
Correct.
not complying with the law.
Correct.
Then there's people who have complied with the law and gotten a rental license, but for whatever reason, there's some issues, I'm guessing, with their properties too. So on those properties, if you can't reach them or you can't contact them, you do have the right to suspend or whatever their rental license and notify them that they cannot collect future rents, which I would think would bring them to you and get it corrected.
Exactly. It's the rent collection that's the hook. Us writing you a violation for not having a rental license, taking you to municipal court, getting a $1,500 fine, that doesn't do anything.
Right.
But it's
It's the rent.
not being able to collect rent. That $1,500 is 2 months of,
The rent is the
1
hammer.
month rent. That's the hook.
And the Revenue Department, I think, is already using this in what's called sequestration. Yes. So where they're sending notices to those tenants of delinquent landlords saying, hey, your landlord hasn't paid us for 3 or 4 years, as of December 1st, start paying your rent to the city of Philadelphia. And it's been a very effective tool. I think close to 90% are paying. So I'm just suggesting maybe that's a tool we could use in L&I instead of, and on this form, by the way, what I don't understand is if you have to fill out a form and it's a managing agent, and I think we should have a managing agent whether you have a property in Philadelphia or out of Philadelphia, and the managing agent could be the owner because they're managing it, whoever it is, just so you have a contact person. And every property owner for you should have one contact person with a phone number and an email. I'm not sure you need faxes anymore.
No, nobody uses fax.
Right.
I don't even know how to use it.
But if we at least had that information, you'd have that one person. I think the concern of a lot of people is that you have a property that has 25 or 30 investors and they want to be limited partners because of liability. And a lot of people just, that's their they don't want themselves in the public eye. I think if you're asking for their names to be disclosed, that's going to become a problem. And my concern is it might taint a little the market in Philadelphia for attraction-wise. And one of my questions was this discussed with the Commerce Department?
I don't know. I don't know who it was discussed with.
Because I would
I can
suggest...
speak, point of information.
Chair
In
recognizes
preparation
Councilwoman
for
Domb.
this hearing, we spoke with L&I, we've been speaking with Health. The answer to your question is no, we did not contact Commerce because we believed in doing the homework for this bill, following up on the work done by the Lead Task Force, and talking with Rochester and talking with Maryland, talking with the Health Department, the L&I Department, and there was another department, Law Department. We did not touch base with Commerce because we don't know why Commerce would have any say in this. And so I'm going to say that this can actually be an and. To quote Councilwoman Maria Quiñones-Sánchez, it takes multiple tools in a toolbox to achieve certain goals. I submit that this should be an and. I'm pleased to say that I didn't know this, but now I know that New York has put forth a similar measure they're being quite more direct than we are, to expose owners of LLCs doing business in New York in order to fight, they are saying, money laundering and tax evasion. Such a bill is necessary to bring political and business transparency and accountability. This bill is about business transparency and accountability so the public can have more confidence that LLCs operate in a way above the board. This bill is strictly about transparency and accountability. We can do all the other tools that have been talked about, which are good, necessary, and probably overdue. We can also do this one.
Thank you. Councilman Domb.
Thank you. I mean, this is a bill that does deal with the business license, right? So I would think that I would just like to hear from the Commerce Department what their opinion is of this bill. Anyway, thank you, Madam Chairwoman. Thank you for your testimony.
Councilman Tollenberger.
Thank you, Madam Chair. If I do nothing, and I'm really not I, but my ABC Corporation does nothing, tells you nothing, maybe doesn't even have a license. What am I getting fined? What's the fine once you catch me?
So the answer is it depends. If you are found to have code violations and no rental license, or just have no rental license.
Let's forget about the code violations in the
Just
sense
no
of,
rental license.
yeah, I run a pretty decent place, my tenants like it, but I've never really got my licensing. You have no contact information on me. What am I getting fined?
If you don't have a rental license and we find out that you don't have a rental license,
Right.
we issue you a violation, we say, come in and get one. And if you come and get one, there's no fine. You come in, you pay $55, you're good. If you refuse to do so, you go to municipal court, and the fine is issued by a judge. L&I doesn't decide what the fine
all
is.
right,
The fine
it's-
comes from the judge. Law can say $1,200 probably-ish.
For a single occurrence?
It really depends.
It really depends, okay.
Totally.
But giving false
People know way more
information,
about
you believe here, it's $300, which I think is terribly too low. And is there in this bill a portion that is where the fine is listed?
There's a penalty and it lists the offense. I don't know if the law department, there are ranges because you end
Yes.
up in court. It depends on the egregious nature of the situation, the property, everyone is given due process, right?
Oh, I understand.
And-
Owners can go into court and plea as to why they're not.
And maybe this is probably my fault, I didn't make this clear. The fine is per day.
Yeah.
So this Class 2 offense,
Okay,
it's
but-
$300 per day that there was a violation.
I'd
So
like
that
to know-
adds up very quickly.
What's the maximum we can do per day? I mean, that gets people's
300,
attention.
300.
That's all we're allowed? Yeah, but still it's low, in certain cases, I would think.
We
But
rarely
if
get that.
it goes back to the date that the violation was first issued, so if you're in court 6 months later, 8 months later, and you still haven't got one, that's $300 per day.
Per day.
All the way back.
Okay.
Obviously, the judge is not going to give that fine. Like,
I
you're not-
understand, but at least it gives the judge, some leeway.
Yes.
Some understanding.
Yes.
And do we have that written in there per day? Is that- It's already in the existing code.
The-
Okay. Okay. Madam Chair, thank you.
Thank you. I think it's important for us to understand that with the new Eclipse technology, what we're trying to do is better utilize the data sets. And I think to Rebecca's point, and I don't know if we want to have Christian come up and speak to a little bit about the challenges that she has and the law department have when we go to court, right? Because then we have to convince a judge, and our ability to really do that maximum fine a day is pretty limited. So I don't know if you want to have somebody from the law department come up to explain it, just so that for the sake of Tollenberger. But I think the utility match, and to Councilman Domb's point, once we get cooperation from the utilities and we can do a match, similar to what we've done in other cases in this property management journey that we've been on for the last 10 years, I think there's an ability to create some of those approaches around creating those buckets, right?
Exactly.
As I said, who has water, who has homestead, who has all these pieces. Until Eclipse fully gets built out, the ability to do all of those things have been hard for us, and a lot of the research has been manual and really cumbersome. You want to identify yourself for the record and explain an egregious case in the court or that hasn't gone the law department's way.
Good afternoon, Councilwoman and members.
Speak into the microphone, we can't hear you.
Yes. Kristen Bray from the City of Philadelphia Law Department. Typically, when the City of Philadelphia brings these cases into court, we can choose one of two forms, one of those being municipal
She's
court.
explaining it, Councilman Tollenberger. I'm sorry, I just want to make sure he, go ahead.
No worries. We have two forms in which we can choose to file cases. One of those is in municipal court, and one of those is in the Court of Common Pleas. We typically try to file cases that are low barriers to compliance in the municipal court system, where we'd only be seeking a fine. So a violation such as obtaining a rental license would be a low barrier compliance violation because it's typically very easy for a property owner to come into compliance with the code. If you have a more substantial violation where we need the owner to take action or we need to take down the property ourselves, that would be something we'd file in the Court of Common Pleas. Oftentimes with the fine structure as it is, which is a minimum of $300 per day per violation or up to $2,000 per day per violation, by the time we're bringing a property owner into court, the fines can total hundreds of thousands, if not millions of dollars, which courts are oftentimes reluctant to impose because they'd rather see the property owner actually invest the money into fixing the property. Along those lines, when you have a violation that is just a rental license, the courts often ask, what is the harm? And they want to not impose maybe a $12,000 fine, which is the municipal limit of the municipal court system, but maybe something smaller, like a $300 fine or a $1,500 fine, which when you've not had compliance for 6 months and you've invested the resources of the Department of License and Inspections and the Law Department, it becomes a cost-benefit analysis of whether that is the most profitable use of city resources. Of course, we would always prosecute, however.
Chair wants to recognize Councilman Domb. You have a question for Christian? No. Okay. You want to stay there just in case, Christian?
Of course.
Okay, thank you. Go ahead, Councilman Domb.
Thank you, Madam Chairwoman. I just want to reiterate, I do think the goal here is to go after the bad actors.
Yes.
So whatever we can do in the area of the rent is the ultimate tool in the toolbox. Escrowing it, redirecting it, whatever it is, it's the rent that will immediately get any landlord's attention. And that should be the focus. The bad actors go after the rent of their tenants and figure out how to get them to the table and listen to you. That's the
Agreed.
key. Everything else is a lot of administration, a lot of work. Once you stop the rent, they have to come to you. They have to come to you right away,
And they have to fix their violations
immediately.
in order to come to us. So-
It is the hammer.
And I'm sure you'll hear that from the advocates when they speak,
Yeah.
that
That's
that
the
is
hammer.
what their tenants are. I mean, if you want to, then there's a whole separate issue of what happens when they do escrow the rent, but that is what we have found. The most effective thing is not the municipal court fine, it's,
Yeah.
it's
Or fines.
where it hurts them, which is
Right.
the rental income.
They have to pay taxes, they have to pay a mortgage payment, they need the
Yeah.
rent to cover those expenses.
Exactly.
What I don't want to do is hurt the good actors. So I want to try to figure out how do we just focus on a category of bad actors where we can attach to the rent. That should be the focus. Anyway, thank you very much. Thank you, Madam Chairwoman.
Thank you, Councilman Domb. Any further questions for our witnesses? Okay, seeing none, thank you. Rebecca, please stand by. For the purposes of time, we had promised the clerk we were going to be out of here in an hour. I'm going to call all of our witnesses, and I want to know for the record that I have all of your written testimony, so I'm going to ask you to please summarize your testimony so that we can get through this. So George Gould, Colleen McCauley, Carla Cruel, and George Donnelly. Please, 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 please. I know y'all all prepared. I'm gonna try to be as nice as Councilman Greenlee is when he asks. I know you're all prepared. Your entire testimony is in for the record, but we're trying to get a vote out of here and not get kicked out of this room. George, you wanna start?
Thank you. My name is George Gould, and I am a senior attorney at Community Legal Services, where I've worked in the area of housing for almost 50 years. I thank the committee for giving me the opportunity to testify on this important issue. I would like to discuss Bills 180-939 and 180-940, which would make important changes to the city code. These two bills were introduced as part of a package of bills by Councilwoman Reynolds Brown to deal with the important issue of lead poisoning in the city. We fully support Bills 180-939 and 180-940. The bills will amend the city code regarding the issuance of rental licenses and require that the owner of the property is not a natural person or a publicly traded company. The application for the license must identify, in addition to the owner, the name and address of each natural person who has an equity interest in the property, and the information has to be updated if changes are made within 10 days. Penalties are also provided for providing false or misleading information. These changes are very important so both the city and tenant advocates can pursue landlords who violate the city lead laws. They are also helpful in finding owners of residential properties who do not properly maintain their dwelling. Basically, what these law bills would do is create transparency in who, in fact, are the ownership interest in this property. And I think in Philadelphia, that's very important. I know, Councilman Domb, you have raised a bunch of issues about people not having licenses. We agree. That's a terrible issue, but we're here today, and we would very much like to deal with that, to deal with this particular issue, and that is making sure that people who do apply for licenses, that it's transparent. However, it's also important to state that these bills are just part of a package of bills that were introduced regarding lead poisoning. Bill number 180-936 was part of that package and is a critical bill that needs to be heard and passed by City Council. While the bill needs some amendments, it's a major step forward in addressing this issue. The bill would make important changes to the city lead ordinance, including requiring landlords of all resident rental properties to obtain a lead-safe certificate and provide it to the tenant in the health department. Currently, the certificate is only required for properties where children 6 or under reside. This has caused major problems in enforcement, as the health department has had great difficulty in determining whether children 6 or under will reside. Of the approximately 26,000 rental properties, only 4,000 have submitted these certificates. In addition, children often visit housing of family and friends where no children reside and no certificate is required. There are other important changes, such as requiring PHA and Section 8 landlords to provide lead-safe certificates and requiring lead-safe certificates upon renewal of lease agreements. I thank you for giving me the opportunity to testify on these important issues. I would also like to thank Councilwoman Reynolds Brown and her staff, in particular Julian, for all their work on this issue. This is a very important issue. Transparency is very much needed in this city. Thank you.
Thank you. Next. Colleen.
Good afternoon, and thank you all for this opportunity for public comment. I'm Colleen McCauley. I'm the Health Policy Director at Public Citizens for Children and Youth. I also facilitate the Lead-Free Philly Coalition that we created a year ago. And in fact, there's folks here from that coalition, from the Children's Hospital of Philadelphia, from Maternity Care Coalition, the Philadelphia Neighborhood Housing CDC, Brody and Rubisky Law Firm, and a couple private physicians that we're working together, putting our collective efforts together to advance changes for the city's lead law to make it more enforceable. I'm also a mother and I'm a nurse, and I want for my son and every newborn son and daughter in Philadelphia to be free of the harm from lead. One more baby harmed is one too many, especially when we know how to protect kids. Childhood lead poisoning is a very serious issue. Every year, 2,400 kids are diagnosed with lead poisoning, and most are under the age of 3, and they are primarily poor and minority. That's enough kids to fill 120 pre-K classrooms. And in some neighborhoods like Strawberry Mansion, more than 1 in 7 babies that are tested for lead are poisoned. Now, to be clear, most Philadelphia children are poisoned by lead-based paint hazards in rental properties. Water is not the main culprit. Schools are not the primary source, because again, the vast majority of kids are poisoned before they're 3, before they even step foot in a school. And owner-occupied properties are not the main source. Health Department data from the Mayor's Advisory Group on Childhood Lead Poisoning shows that more than 60% of kids are poisoned by rental properties. NBC 10 recently featured a story about twin 2-year-olds who lived most of their lives in an apartment on 5th Street owned by the Philadelphia Housing Authority, and both toddlers were poisoned. PHA-owned properties are exempt from Philadelphia's lead law because they were required to be made lead safe years ago, but tragically, some are still not safe. The twins' mom, Ms. Erica Miller, explained about her children that, quote, "I won't know what their full potential will be because at the end of the day, they got lead poisoning." Since lead-based paint in rental homes is primarily making babies sick, the solution is straightforward. Find lead-contaminated properties and get the lead out, and that's what the lead law was designed to do. The 2 bills the committee is discussing today are part of a package of 5 bills intended to increase protections for children from lead hazards in their rental homes and properties. And again, we've discussed the purpose and the significance of these bills. But I'd like to note that just last week, the Law Department fulfilled PCCY's right to know request and sent me a list of landlords to whom the Health Department had issued code violation notices. These landlords were required to comply with the lead law and submit a lead-free or lead-safe certificate, or to document that they were in fact exempt from the law, but they didn't do any of those. So from March 2017 to April 2018, the Health Department sent code violation notices to rental property owners of 2,490 properties. And among the property owners who have since paid the fine or haven't responded to the department yet, 1/3 are listed as corporations. For 1 out of every 3 parents living in a property on that list, they don't have all the critical information they need to use the lead law to protect their children from possible lead hazards in their homes. And tragically, for some of these parents, it's too late, because their kids have already been poisoned by the lead hazards that went undetected in their rental property because their landlords failed to act and enforcement of the law lagged behind. So I urge you to support the 2 bills before you today to improve transparency and put more power in all of our hands here in Philadelphia. And again, while these two bills are important, they play a more tangential role among the package of 5 lead poisoning prevention bills introduced last month. The bill that will go the farthest to protect tens of thousands more babies and toddlers is Bill 18936. That calls for expanding the lead law to almost every pre-1978 rental property. The current lead law is targeted at properties with kids 6 and under, and since its passage in 2011, it's proved to be almost entirely unenforceable. Many landlords have been conscientious and complied with the law, but most have not. As of January 2018, landlords have only submitted 4,418 certificates for an estimated 26,000 rental units subject to the law. There is no record of tenants' ages, so there's no way to identify pre-1978 properties rented to families with small children. We don't think there should be a record of tenants' ages out of concern that this could fuel the possibility of discrimination against families with young kids. And the city does not know exactly where landlords are out of compliance. Again, as a case in point, landlords of almost half of the properties the health department issued a code violation notice to were ultimately found not to be in violation. They weren't in violation of the law. They didn't have to pay the fine because, for example, a kid under 6 didn't actually live there, or the landlord didn't own the property anymore, or the property was built after 1978. So to address the law's shortcomings, the Mayor's Advisory Group on Childhood Lead Poisoning recommended improving the law's enforceability by requiring all pre-1978 rental properties to comply.
You want to call on me?
Councilwoman, I'm sorry, excuse me, Councilwoman Blondell Reynolds Brown.
Could you please focus on these 2 bills? That's what we're trying to get accomplished today. That's very, very, very important. We can't be all over the place. We have to move this train down the road one stop at a time. Thank you.
So I do urge the committee to support Bill 18939 before you today. Thank you.
Thank you. Carla? Okay. We have your written testimony.
No,
too.
there is no written
Oh, there's
testimony,
not.
and I will be brief, I promise.
Okay,
I know that
and
time
then
is of
George
the essence.
Donnelly.
Yeah,
Okay.
correct.
All right.
Good afternoon, council members. My name is Carla Krull. I'm a staff attorney at Turn. I have multiple roles. I also work as the courtroom navigator. So I'm in court every day interacting with tenants. I also do a background check. It's a landlord-tenant background check for Turn. So tenants are able to check and find out information. It all goes through me. These 2 bills are actually quite essential. On a regular basis, I actually hear tenants in court saying they don't know who their landlord is, even though they're being evicted by their landlord. And one of the reasons this goes about is change of ownership. So when the property is sold to another LLC, so it goes from one LLC to the next LLC, and they were dealing with a management company, sometimes the management companies are changing in that time frame, so they don't know who to pay their rent to. They don't know who owns the property. And the first time they're ever meeting someone is the day that they're in court when they're about to lose their housing, right? And now their name is in a system that's affecting them going forward. So that's one of the reasons why it's really important, because if it does change ownership and it's a public record for L&I, a tenant could look up on L&I's system and find out who their new owner is. And if they do want to pursue and pay rent to someone, they know exactly who to pay the rent to. But the way the system is working right now, it doesn't necessarily work. And this includes people who actually already have licenses. It's not just about people who are unlicensed, it's also those who are licensed. A lot of the properties are changing through sheriff's sale now, and I also do a lot of training around the city. I do training for both tenants and landlords. And I've been in rooms where landlords, new people who are doing construction or buying property in Philadelphia, are encouraged to put their property in the name of an LLC in order to hide themselves, in order to protect from liability. And so what ends up happening for tenants is just simple things. It's not just about repair issues, because that is a part of it. But sometimes it's just getting their security deposit back. So someone owned the property initially, and they say, well, it's changed ownership, and it didn't. Sometimes it changes through sheriff's sale, and if it changes through sheriff's sale, trying to pursue who has their money from before because they were only dealing with a management company. And as long as the management company has said who was the owner of the property, then the management company is not responsible. So just having a management company is not helpful either. You need to know who the people are behind it so you can pursue them, especially when it changes ownership for security deposit. And tenants, when they don't have a lawyer or have a lot of money to do a lot of research, when they go over to municipal court, the first question they're asked is, do you have an address for your landlord? If you don't, you can't sue. And they send them over to Turn. And then I'm on the internet searching, trying to find an address, a real address for a person in order for them to sue just to get their security deposit back. So it's just a very simple thing that lowers the hurdle. A lot of the statements that were made earlier, we were talking about putting a lot of, you already have law in place, you have the licensing, but there's a trickle down effect for people who don't have lawyers and who aren't representing them. So if they're constructively evicted, if L&I has to shut down a property because it's an unsafe property and that tenant needs to pursue a LLC in order to get the legal remedies that they need, they're stuck, right? They don't know who to give service to because you can't serve a P.O. box, right? So all of these things are really important. I've done a lot of work on background checks. So I send out letters to tenants who have reached out to us because they want to know about a property. And I've actually had a management company, is one management company that manages over 2,000 properties in the city of Philadelphia with 625 different LLC names, right? So when those owners of the LLC decided that they wanted to change and not use the management company, all of the licenses have the address of that management company. So any tenant that needed to sue under the lead paint law, any tenant that wanted to sue for constructive eviction, any tenant that wanted to sue on any issue at all, have no real address to seek a remedy, so they can't sue in court at all. So for all of those things, as I was listening, there was a lot of trickle down that was going to put a lot of hurdle on the tenants, and then ultimately, if you start doing that, it'll make it easier for landlords to do illegal lockouts, right? And they'll just not go to court. We don't want to get to a point where no one can get any remedy in the court at all, right? Just knowing who a person is and being able to engage that person simplifies the process for everyone. Thank you.
Thank you, Carla. That was very informative. George Donnelly?
So Carla hit on most of the points that I wanted to touch on, so I'm going to give a very specific example. My name is George Donnelly. I'm an attorney at the Public Interest Law Center here in Philadelphia, and I want to talk about a property management company, possibly the same one that Carla was mentioning. This problem of lack of transparency that we're very thankful that Councilmember Reynolds Brown has introduced these bills, because they really tackle this transparency problem that is rearing its ugly head as a lot of investors, many if not most from out of town, are gobbling up properties in the poorest neighborhoods in Philadelphia at sheriff's sale, right? And so there's an entire industry behind passive real estate investment in poor neighborhoods in the city. There's this property management company. It specializes in renting to low-income individuals, and it brags that it's the largest cash buyer in Philadelphia for 3 years running. It says it's the model of the passive property venture industry, and it helps investors organize LLCs through which they can purchase properties and remain anonymous. And this practice takes a huge toll on the health and well-being of tenants, because these anonymous investors can't be contacted by tenants or by the city, as you heard from Ms. Swanson, when the houses fall into disrepair. Of course you can contact the property management company, but let me tell you, again, a story that's in my testimony about this. So I currently represent 2 families in lawsuits against this property management company. I've had problems serving people, just like Carla alluded to, and we've sued the LLC clients who own the properties as well. In both cases, my clients requested repairs to their homes to fix things such as a sewage explosion in the basement, a major water leak that led to a collapsed ceiling in the kitchen, hazardous electrical issues, a broken front door, lack of running water with an infant in the house. And in both cases, the property management company failed to make the repairs even after cited with housing code violations. There was no way for my clients to contact the actual owners. It's an LLC name with the address of the property management company. And it's unclear if the owners knew of all these issues. In fact, In public court filings last month, the property management company accepted service on behalf of its LLC client and admitted it didn't tell them about it. It admitted that it didn't tell them about the lawsuit. And I'll be happy to answer your question.
Just a point of information here.
Councilman-
You're saying, I'm sorry,
Yes, go ahead.
that the property manager did not tell the actual owners of the LLC of the lawsuit?
That's exactly right.
And what excuse
Councilmember.
did they use?
They didn't have one,
They
Councilman.
just said, we just
They
not.
acknowledged it.
Okay.
Yep.
Okay.
They didn't have an excuse. It's good. And this is the point that I
Madam
wanted to
Chair,
make
thank
to,
you.
say it again.
I just said thank you.
Yep.
But if you want to elaborate further. No. You want to elaborate further,
I
please.
want to elaborate.
Please.
Just briefly
Please.
on it.
Okay, thank
You know, as a good business person, you would want to know if the people that you hired aren't doing their job. And that's something that right now is very difficult to do for the city and for tenant advocates because we don't know who owns these LLCs. And so the last thing I want to say is as a city, we can't allow these largely out-of-town investors to continue to profit off of poverty while remaining anonymous. We need to know who owns homes in Philadelphia. We have to, so that we can hold these people accountable when they fail to maintain their properties. And this isn't a novel issue, just like Council Member Reynolds Brown said. Other cities do this. Rochester does this. New York City does this. So these are things that other cities do. We should join their ranks. Thank you, Councilmember Quiñones-Sánchez and Councilmember Reynolds Brown. Thank you for introducing these bills. I urge the committee to support them.
Thank you. Chair recognizes Councilman Tomberger. You have any more questions?
No, I'm good.
You're
Thank
good. Just for Carla and for George, you know, the notion that this doesn't happen frequently, right, for folks, because again, the folks who are good actors, right? How many families have you represented this year and what percentage do they represent of folks that something as simple as knowing who the owner is could have facilitated the resources that you're expending?
So, two things before I answer your question. One thing I did also want to add is that in those properties that I was talking about, 142 LLCs that are not registered in the state of Pennsylvania, so which means they can't own property in the city of Philadelphia. There's 142 of them who have an address and they have a license that's under the management company, which means they're renting out properties, evicting tenants, and they're legally not even supposed to own property. So to answer your question, because I'm a housing counselor as well, I would say that I run into this issue probably at least once or twice a week, working with tenants. And the reason why I say that is it comes up in issues of fraudulent landlords where someone has gotten scammed and they thought they owned the property, but there was no way for them to actually check and find out who really owned the property. And we also see it a lot changing ownership when an LLC has bought it when the property was lost through sheriff's sale. So that most of these issues I'm finding with an enormous amount of families, particularly in the poor neighborhoods, right? Mm-hmm. So the poorer the neighborhood, the more they're scooping up the properties in sheriff's sale. And you have children, families, but I would say I see probably in just one-on-one 2 tenants per week. And then sitting in court, I have to hear at least, I'm there 5 days a week, so I would estimate that at least 3 times a week, just a tenant in court is telling me that they don't really know who the owner of their property is.
Yeah, as you're aware, CLS represents a large number of tenants, and this is a very common problem. Tenants come in, they don't know who the owner is, it's an LLC, the problem is in very bad shape, and it becomes very difficult for them to get repairs done, and also for the city to get it done. Probably 6, maybe 5 or 6 cases a week would be under this situation. Quite frankly, it's bad.
Yep. The other George?
I
forgot both of you are George.
I have, two Georges. Glasses George and non-glasses George. I have 5 affirmative cases in federal and state court right now against LLC owners, and I've had problems serving 4 of them. And I don't know the actual human owners behind 3 of them at this point.
Question, because you meant, and to Carla, you mentioned the issue of the LLC not even having a business license in Pennsylvania?
Yeah, so what some of the management companies do because they can use an agent. The agent will get the license on behalf of the owner, but the owner is an LLC, and the LLC is actually a foreign agent. So, like I said, part of what I do is do background checks. So we've been actually trying to go through the city and look for places where we find an LLC, and we look in Pennsylvania, the Harrisburg system, to see if they're a registered agent. And just for this one management company, we found 142 that either weren't registered or was kind of questionable whether they had registered or not based on the name.
Okay. Thank you. Any other questions for Councilwoman Bondell Reynolds Brown?
Yes, to Project Turn, thank you all for your insightful review of the facts, because it's the facts that move us to this table. So just underscore, if you will, you said that you cited examples of why having a managing agent, why knowing who the name of the owner is has been a hurdle, even when it comes to something as simple as returning someone's security deposit. Just speak to that and underscore that for me.
Yes, so when tenants go on their own to try to sue in municipal court, the clerks of the court they've been given instructions to make sure that the tenants have what they need in order to sue. So the first question that they're asked is, what's your owner's name and what's their address? And tenants will say, oh, I always paid my rent in cash, I don't have an address. Or they would say things like, oh, I have this P.O. box number, and you can't serve a P.O. box. So, and if you actually go through a lot of the leases, a number of leases say notice for the LLCs is to a P.O. box. And so as soon as they try to get a P.O. box or they don't know the address, they're turned away. And then the court actually sends them to turn and tells us to go find an address. And sometimes I can't find an address. It's actually impossible for me to find an address. And at other times, we have to go through the Department of Records. We have to go back to the point in which they actually recorded the deed. And if we're lucky, if they actually included their incorporation documents there, we can get it there. But sometimes the incorporation documents don't even have it either, so then there's no way for us to find them.
Yeah, let me just mention, we incur exactly the same problems, and we work with Turn to try to resolve it, and quite frankly, that's why these bills are so important.
Thank you. Councilman Domb?
Thank you, Madam Chair. I just have a quick question for Ms. McCauley. I was not aware of this. In your testimony, you're saying that PHA had 2 cases of lead poisoning, and they're exempt from the law?
Yeah, PHA currently is exempt from giving a lead-safe certification under the current lead ordinance. That's correct.
And why is
Their
it?
own federal requirements.
Except they have lead in their properties.
Well, quite frankly, what PHA does under federal law, they just do a visual inspection of properties, determine if there's peeling paint. They don't do what's called a dust wipe, which is required under the lead-safe certification. And that's why the current bill that's been introduced would put PHA and Section 8 under the requirements for the lead-safe certification.
Okay. All right, thank you very much. Thank you, Madam Chair.
Thank you. Councilman Tallenberger?
Well, just a statement. I can't believe that that we're asking private citizens, private owners, to do something that our city government or government in PHA doesn't need to do. I think that's doesn't make any sense to me. I mean, that's just a statement. I mean, it's nonsense.
I would agree with you, and that's why Councilwoman Reynolds Brown has introduced a bill that requires them to do it. And that's why.
Is that part of this bill?
No, it's part
all
of the
right.
package.
Got it. Okay. I don't want to confuse. There's enough confusion. We don't want to confuse.
There's federal law that governs the way PHA is supposed to do this business, and there's loopholes that we've been talking about. There's a cost. They were supposedly given opportunities to submit remediation plans. It's a longer process that I'm sure when Councilman Reynolds Brown's bill comes up.
No, I understand.
PHA will explain what it considers to continue to be its impediments for compliance. And I said it earlier to the doctor. I got lead in a PHA property when I was a child. And so I am a product of some of the challenges that we faced. Yeah, thank you. Any other questions, Councilman Domb?
Well, only if they would know. How many cases of lead do you think exists? Well, I think you said from PHA there's 2, and in the city as a whole. How many lead?
I was just given this information by Dr. Dallenberg, a CHOP pediatrician that's in the back here, council member. And again, that's not the focus of today's bill.
I understand,
Since
but
you
I'm
asked,
asking.
it's 3,500 children in Philadelphia last year tested positive for lead above the level of 5, which is elevated levels. That's 10% of all children tested in the city. And as Dr. Dallenberg will tell you, that's likely an undercount because it's only kids that are tested and only kids that are reported.
But we're not sure if that lead came from the lead in their homes or lead in the soil? Oh, we are sure.
Can we talk about that?
Well, I'd like to know how many violations, I guess in the health department has that, how many actual violations there are about lead in buildings. I mean, not all buildings, in homes,
I
apartments.
don't know. I
Somebody
don't know
has it.
the exact number currently.
And it's also going to be hard for them to find out because they only
All right.
find out if the kid is tested, it goes above a certain number, and then it's sent over to the Department of Health. So there's probably plenty of other children that are sick.
And
we
just for the
won't
record, I'd just
know
like
the
to check
numbers.
that sometime down the line. I don't
Yeah.
need the answer right now.
Yeah.
Thank you. Madam Chair.
And folks, as, again, representing one of these, some of the poorer sections, people move frequently, and really tying in lead poisoning to a child whose family may have lived in 3 and 4 units in the last couple of years is very hard because lead stays in your blood and so forth and so on. So, thank you to all of you for your patience today.
I would like to,
Okay, so this concludes the public hearing. We are going to go into our public session. We're going to take a 2-minute timeout. We need the physical amendments.
Yeah, they're in the package.
Extending the, okay, the Committee on Licenses and Inspections will now have its public meeting. Before we move the amendments to both bills that have been circulated to the committee, Councilman Domb wanted to make a statement for the record, and then I'm going to ask Councilman Greenlee to move the amendments.
Thank you, Madam Chairwoman. I just wanted to explain my vote on this issue, and that is, I will be voting no, and for this reason. I'm in favor if it's a managing agent and one primary owner, one, not more. So if the bill is amended to that, I'm in favor of it, but until the bill's amended, my vote would be a no. Thank you. Thank you, Madam Chair.
Thank you, Councilman. I think it's important as a councilwoman who has worked and met with folks. I think she's always open to further discussions, but I think our witness folks have made a very good case about the challenges related to ownership and transparency. Chair, Councilman Tallenberger, before the motion, did you want to?
Well, no, I'd like to make one comment.
Yes,
and that
please.
is, I am going to vote aye, because my colleague has put a lot of time into this. However, she also said to me and to us that she is open to amendments and discussion on that. And for that reason, I'm voting aye. But I will also be very blunt. If I think at the very end of the day that the amendments don't cover the things that I need to think that ought to be covered, then I will vote no on final passage. But I will vote and move the bill today. A lot of hard work, a lot of witnesses, but I'm still very troubled by some of the things, and we'll work that out. So.
Thank you. Thank you, Councilman Tallenberger. That said, the chair recognizes Councilman Greenlee for a motion on the amendments to Bill 180939 and 180940.
Thank you, Madam Chair. I move the adoption of the amendments to Bill numbers 180939 and 180940 as they were distributed.
Second.
All those in favor?
Aye.
All those in opposition?
Nay.
Nay. Let the record reflect that Councilman Domb has voted against it. The chair recognizes Councilman Greenlee for a motion on the amended bills as stated.
Thank you, Madam Chair. I move that the following two bills be reported out as committee with favorable recommendation, and that the rules of council be suspended to allow for first reading on our next session of council. Bill number 180939 as amended, and bill number 180940 as amended.
Second.
All those in favor?
Aye.
Any oppositions? Let the record reflect that Councilman Domb is voting against it. That said, Bill number 180939, 180940 will be moved out of this committee with a favorable recommendation and rule suspension to allow first reading at our next session. Thank you, everyone, for your patience today. This concludes the Committee on Licenses and Inspections.